I will tell that Contract Act does not tell us what rights and duties we have. We create them by ourselves. The Contract Act just only tells us that if you do this, this is a valid contract. If you do this, so this is not told by the Contract Act. We decides our rights, our duties in the contract. So as Contract Act is a pre independence statute, so thereby we have many English law prevailing till now, and our judiciary follows them. So the contract so having said so, now I would like to deal with the doctrine of privity. So what is actually a doctrine of privity? So by defining the word privity, privity means privacy, privacy between the two parties to the contract, the promisor and the promisee. The promisor made the proposal. The proposal can be uh, used as a synonym term with offer also. Offer is an English term, but in Indian Contract Act we have the term proposal defined. So thereby, when a proposal is made and that very thing is in the same sense is accepted, that is a contract. So if the promisee says that there was some third thing that was decided, so no, that is not the part of the contract, because that wasn't accepted by you, because that proposal wasn't made by the promiser. So the contract, both the parties are bound by the terms and conditions of the contract, and the terms and conditions are decided by the parties themselves according to their facts and circumstances, and for the thing they want to create a contract. So for example, I being the promiser, you being the promisee. So I offer you that I want to sell my 100 kg rice to you, and you say, okay, I will buy, but I will give not the thousand, but I will buy it for 1,000 rupees. So thereby, the consideration here is 1,000 rupees, and for me, the consideration is giving you the rice. So thereby, that is a valid contract. By coming to doctrine of privity, privity means privacy, privacy between the two parties to the contract, the promiser and the promisee. Privity of contract means that only the parties to the contract can sue and the third party cannot. So here, if some third person comes and say, I wanted to buy that rice, so no, that cannot happen, because I made the contract with the promisee itself. So if I do not deliver the rice, or I do not deliver the same quantity or the same quality that was decided by us, the promisee, he himself has to sue me. No one else can do that. So that means privity. Privity is between two parties, the two parties to the contract. So if I elaborate it more, doctrine of privity, so that means that a contract cannot confer rights or impose those obligations arising under it on any person except the parties to it. But this is not the case. So when we talk about consideration, so when I was reading the definition of the consideration, so you guys might have read the promisee or any other person. So here the any other person plays a vital role. So here in the doctrine, the any other person. So there are two parts: one, privity of contract; two, privity of consideration. So in Indian law, we have privity of contract. So the third party cannot sue, but we as English law has a privity of consideration also, but we do not have, because our definition is very wide. So our definition also says any other person. So like for example, I tell you that I want to give my watch for 5,000 rupees. You say okay, but your mother gives you the money for that watch. So now your mother becomes a party to the consideration, not to the contract. She's not the stranger to, she is stranger to the contract, but she's not the stranger to the consideration. So if I do not deliver the watch, your mother can sue me, because she was still the party to the consideration. You being the promisee, you are stranger to consideration. So if I put it in a better sense, so I, promiser says, I give you my for example, Titan watch for rupees 5,000, and you say okay, I will buy, but the money is given by your mother. Your mother, now the stance of your mother, the stance of your mother is, she is not the party to the contract, she is stranger to the contract. But she is not stranger to the consideration, she is party to the consideration. You are stranger to the consideration. So if I put it in a better sense, so now the parties to the consideration are me and you. But sorry, party to the contract are me and you, and party to the consideration is me and your mother. You are now being stranger to the consideration because you haven't paid the money, your mother has paid the money. So uh, if I put it again, the definition of the consideration, so it means either one, either the promisee pays the consideration or some other person on behalf of the promisee does the particular act which has been decided by the parties. So now Contract Act does not limit itself to two parties. Now we make commercial contracts, big contracts, and here also the beneficiaries are entitled, the shareholders, and there are many parties involved. So the consideration does not have privity of so in the sense I would say that there is no privacy in consideration, but there is privacy still prevailing in the Indian judiciary about the privacy of contract. So, putting further, so I will give an example as I already gave. So, here in the contract, in the sale of 100 kgs of rice for rupees 10,000, now on behalf of B, if the promisee's mother pays, so she being the party to the consideration, not the party to the contract. I am emphasizing it repeatedly. She is stranger to the contract, but she is not stranger to the consideration. Uh, so if a person is sometimes party to the contract, I already focused on that point that she can be consideration. So there can be a stance that where a party is uh, stranger to the contract but stranger to the consideration. But this particular situation would arise only in Indian law, not in the English law, because English law still says that there is privity to consideration as well. And as we follow English law, because that's a pre-independence act, so some principles we are we have been taking and we've been following, but as our situations, our facts and some circumstances are different, we are daily we are evolving, judiciary is coming up with uh, new judgments, new interpretations, so thereby we concluded that we cannot have privity of consideration as our Indian Contract Act in the definition particularly says promisee or any other person. So if